The Trump administration has until midnight Wednesday to restore funding for foreign assistance programs. A federal judge on Tuesday rejected a last-minute attempt by the administration to keep the money frozen while the case plays out. President Trump has sought to put nearly all foreign aid programs under the purview of the State Department and U.S. Agency for International Development on hold for further review.
Trump administration hit with triple legal blow in 90 minutes. In a stunning sequence of events, President Trump's administration faced 3 separate legal setbacks in just an hour and a half, each one challenging executive decisions on funding, federal aid, and refugee policy. The first blow came from a federal judge who issued a temporary restraining order over the Trump administration's freeze on foreign assistance funding. According to court transcripts, the judge appeared frustrated with the lack of clarity from government attorneys, pressing them repeatedly for specifics about the funding pause. He was reportedly shocked that Department of Justice lawyers could not provide factual updates on why hundreds of millions in foreign aid remained stalled. The court ordered the funds to be released by midnight, a bold directive that sent shockwaves through Washington. Although the DOJ is moving to appeal, the deadline stood at the time of the ruling, forcing agencies to act quickly. USAID, the federal agency responsible for foreign aid, was left scrambling to comply. It's not yet clear whether the administration will meet the court's demand on time, but this marks a sharp judicial reprimand for how the White House attempted to halt foreign funding without adequate explanation. The second decision came from a separate federal court ruling that blocked the Office of Management and Budget, OMB, from pausing various forms of federal assistance, including grants and loans to nonprofit organizations. The ruling centered around the administration's attempt to halt the processing and distribution of these resources under the argument that they required additional compliance reviews. The judge disagreed, stating that nonprofits had successfully demonstrated the potential for economic catastrophe if these freezes were allowed to move forward. More notably, the court criticized the administration's unrealistic expectation that agencies could conduct a full-scale review of compliance in just 24 hours. It ruled that the burden placed on organizations and government offices alike was simply too high. The pause was struck down. In both cases, the judges stopped short of saying Trump lacked legal authority to initiate funding freezes. Instead, they underscored a lack of due process and planning. In short, the rulings were less about whether the president could act and more about how he tried to do so. Then came the third and perhaps most consequential ruling, a preliminary injunction blocking Trump's attempt to stop refugee resettlement efforts under a decades-old federal program. This case reached into the core of executive power. Though courts have often upheld broad presidential discretion over immigration policy, the judge noted that this particular refugee program was created by Congress over 40 years ago and had admitted over 3 million refugees since its inception. By attempting to halt the program unilaterally, the Trump administration may have overstepped the legal boundaries of presidential authority. The ruling acknowledged that while the president holds significant leeway in immigration matters, that authority isn't limitless, especially when it comes to long-standing programs established by Congress. The court emphasized the need for balance between executive discretion and legislative oversight. Legal experts say the fact that all 3 decisions were issued within such a short window illustrates a broader trend. The courts pushing back against abrupt executive action without sufficient legal grounding or preparation. For the president's legal team, this sudden flurry of setbacks poses serious challenges, not just in implementing policy, but in framing the narrative of presidential authority going forward. But the courtroom battles don't stop there. As the administration navigates these legal defeats, attention is now turning to a separate storm surrounding the January 6th investigations and the Department of Justice. Specifically, there's renewed pressure on Judge Aileen Cannon to lift her injunction and release the full second volume of Special Counsel Jack Smith's final report. This second volume reportedly centers on the classified documents case involving Trump. It's been kept sealed because co-defendants in the case still have pending matters in the 11th Circuit Court of Appeals. Judge Cannon, who has presided over that case, previously blocked the release of the report. Now, a coalition of legal experts and First Amendment advocates is pushing for the report to be made public. One argument gaining traction comes from the Knight First Amendment Institute, which claims that once the report was formally submitted to the court and used as a basis for the judge's decision to issue an injunction, it became part of the judicial record. That, they argue, means there's a presumption of public access. In other words, it may no longer be up to the Department of Justice to decide whether the report is released. The ball is now in the court's hands, literally. Judge Cannon is expected to issue a new ruling soon. If she refuses to release the report, advocates say they'll take the issue to the 11th Circuit in an effort to override her decision. If the report does become public, it could expose sensitive details about the classified documents investigation, potentially fueling fresh controversy around Trump's legal exposure. But even more than that, it could open a debate over what the public has a right to know when it comes to judicial records and presidential investigations. What makes this moment particularly volatile is the timing. Trump is currently campaigning for re-election amid a swirl of lawsuits, legal rulings, and ongoing investigations. For his supporters, the court decisions are seen as obstacles placed by a deep state intent on derailing his agenda. For his critics, they're signs of accountability finally catching up. The White House has not yet issued a formal statement on the string of legal defeats or the renewed calls to release the Smith report. DOJ officials, meanwhile, are staying tight-lipped. But one thing is clear. Yesterday marked a turning point. In less than 2 hours, the Trump administration's legal momentum took a serious hit, and the road ahead is growing increasingly unpredictable. In the hours following the triple legal defeat handed to the Trump administration, Washington went into a state of frantic recalibration. The rulings were clear. The courts were no longer granting the benefit of the doubt to executive actions taken without thorough explanation or legal backing. But it's not just the immediate impact of these rulings that has the White House on edge. It's what they signal about the months ahead. Inside Trump's inner circle, the legal setbacks have triggered what sources describe as a tightening of the perimeter. Lawyers and advisors are reportedly working overtime to prepare for the next wave of litigation. A key concern: whether the courts will continue this pattern of intervention, potentially paralyzing key aspects of Trump's second-term agenda. Already, legal scholars are noting a pattern. The three cases may have involved separate issues: foreign aid, federal assistance, and refugee policy. But they shared a common theme: abrupt policy moves executed without clear structure, followed by judicial resistance. If that pattern holds, the administration could be facing more than just temporary setbacks. They could be staring down a crisis of credibility in the federal courts. Outside the legal trenches, the political fallout has begun. Republican lawmakers have quickly closed ranks around Trump, calling the court rulings examples of activist judges undermining the will of the American people. Some far-right voices online have taken things further, openly calling for impeachment proceedings against judges who ruled against the administration. These calls, though unlikely to go anywhere procedurally, have added fuel to an already polarized national debate about the role of the judiciary in checking executive power. At the center of this firestorm is President Trump himself, who spent much of the morning reposting favorable commentary from his base and warning that the legal system was weaponized against the people. During an impromptu statement outside the White House, Trump called the rulings a disgrace to democracy, claiming that radical judges are trying to stop this administration from doing what we were elected to do. Critics were quick to point out that two of the judges involved in the decisions were Republican appointees. Meanwhile, advocacy groups representing immigrants and international aid recipients have cautiously welcomed the rulings. For them, these injunctions are more than just legal victories. They're lifelines. Several nonprofits involved in the blocked funding programs say they were within days of shutting down operations due to the freeze. Now, with the court's decision, some breathing room has returned. But many remain on edge, knowing that the DOJ is likely to appeal. The refugee ruling in particular has reignited debate over America's global commitments and moral responsibilities. The Trump administration had attempted to pause all refugee resettlement under what it described as national interest concerns. The court, however, said the move violated the structure of the 1980 Refugee Act, a law designed to ensure that refugee admissions remain a shared responsibility between Congress and the executive branch. The judge ruled that no unilateral shutdown could occur without proper congressional consultation. Policy experts say the court's message was unambiguous. Long-standing systems can't be dismantled by memo. Still, Trump's base remains unmoved. Online forums and conservative influencers have already begun reframing the legal losses as evidence of deep institutional bias. The message is consistent and simple. They're afraid of change. But while the political spin machine hums, the legal consequences continue to stack up. Over at the DOJ, the battle over the release of Jack Smith's classified documents report is gaining urgency. The motion filed by the Knight First Amendment Institute argues that the report, submitted to Judge Cannon as part of the DOJ's case strategy, should now be considered public record. And because the judge cited it in her injunction, the public has a right to see the full context. This isn't just a technical argument. It's a foundational question about transparency during politically sensitive investigations. If the court agrees, it could force the hand of both the DOJ and the Trump legal team, who may now have to answer publicly for findings that have so far remained behind closed doors. Legal observers are also closely watching the implications for other pending Trump cases, especially the broader January 6th investigations. If the courts begin asserting a stronger hand in how presidential actions are scrutinized, it could reshape the balance of power between the executive branch and the judiciary in profound ways. Trump's allies, however, continue to insist that the courts are overreaching. Senator Mark Holland, one of Trump's most vocal defenders on Capitol Hill, issued a scathing statement. We are witnessing an unprecedented judicial hijacking of executive authority. If the courts believe they can govern by injunction, then we are no longer a republic, but a courtroom bureaucracy. Others in the Republican establishment have taken a more cautious tone. One senior GOP strategist, speaking anonymously, said the administration needs to rethink its approach. They can't keep doing things by decree and expecting it to stick. Courts are demanding more structure, more explanation. If they don't adapt, they're going to keep losing. On the Democratic side, the mood was less restrained. House Minority Leader Clara Mendoza called the rulings a long overdue check on reckless power. She added that the decisions prove no one, not even the president, is above the process required by law. Back at the White House, the response strategy appears to be twofold: fight the rulings in court and amplify the political message outside of it. That means more social media posts, more interviews on conservative outlets, and more attempts to cast Trump as a victim of institutional resistance. But even among Trump's advisors, there's an acknowledgement that these legal storms aren't just momentary. They're part of a deeper reckoning between the executive branch and the rule of law. One aide reportedly told a journalist off record, "We didn't think the courts would move this fast. Now we're playing catch up." As the legal appeals begin and the push to release the Smith report gathers momentum, Washington is bracing for another wave of headlines, hearings, and courtroom drama. But one thing has changed. The sense of invincibility that once surrounded the Trump administration's executive orders now appears to be cracking. Whether that crack turns into a collapse or a new strategy remains to be seen.